Your in conclusion, it is therefore our prayer that whereas several of our precedents and jurisprudence in the country does not take pre-charge detention, this is a unique circumstance. That calls for the court to grant the state the fair support.
It's easy as maybe I'm just doing preliminary.
To ensure that the right to property, the sanctity of life, and the need to preserve the integrity of the administration of justice is upheld. We therefore pray for the suspects to be detained as claimed by the investigating officer. Thank you.
Counsel, you had said you are cross-examining without any submissions.
If the record captured that way, then
Yes, that is what
I did not assert that.
are you calling?
We have to if the record captures that, then we can strike it out of the record.
There.
We have to strike that out.
When counsel said
The IO.
yes,
Yes,
during
I was
the
opposed
IO's
to the line
cross-exam,
of him submitting on grounds that
she
were not.
asked you whether you were going to submit or cross-examine.
Your Honor, if my memory serves me right, when he made allegations on factual issues that were not on the ground.
Instead of all this, which is a considerable consumption of time, yes, you can clarify then.
Oh, very well.
I wanted a clarification on whether the council should be allowed to first cross-examine and then later on submit, or we should submit first and then later on cross-examine. So his right to submission was not.
Okay, but let it not take 20 minutes of the court's time.
Your Honor,
Briefly.
I'll take 5. I think we'll allocate each other 5 minutes, so that will come to 30 minutes. Very well, Your Honor.
No, not 30 minutes, the court's time, not your time. We have other accused persons waiting for justice.
Very well. Your Honor, I'd refer this court to Article 21(1) of the Constitution, which gives this honorable court the fundamental duty of the state and every organ to observe, respect, promote, and fulfill the rights and fundamental freedoms in the Bill of Rights. So all actors, be it the court, be it the ODPP under Article 157, and even advocates under Section 456 of the Law Society of Kenya Act, we are enshrined or enjoined by the Constitution to act in that manner. Your Honor, it is unfortunate that the proceedings and the application before you has been brought under circumstances which I'll shortly demonstrate that are in clear violation of fundamental rights and freedom of the suspects. Very important and preliminary, Your Honor, is the provision under Article 49(1)(f), which provides an arrested person the right to be presented before a court as soon as reasonable, but not later than, Your Honor, 24 hours after being arrested. Your Honor, the prosecution has craftily averred that they placed the suspects in their custody at around 2000 hours on 7. Your Honor, even if we were to go by their submissions, which we oppose and strongly deny, because most of these suspects were arrested way before that time and have spent more than 36 hours behind custody, Your Honor, that article enjoins not 24 hours. It is within 24 hours. And they have not endeavored absolutely to give any reason whatsoever or any circumstances that would have prompted for them to invoke Article 49(1)(f)(2). That is why they brought them after the 24 hours. So that is a clear violation. Your Honor, that is important for us by dint of Article 25A of the Constitution, which provides for human dignity. Your Honor, we can argue all we want, but one of the fundamental freedoms, Your Honor, is the right to be treated in a humane way, not in a degrading manner, and not to be punished. Your Honor, most of the suspects here in contravention of the same have been inhumanly treated. They have been punished. Some of them are limping. Some of them are injured. And Your Honor, very unfortunately, they are malnourished and famished. They have not eaten. Your Honor, in fact, with the indulgence of the court, we will be seeking, because we have well-wishers who brought some bread and milk, if they could be served with the same, Your Honor. From the face, you could see. Your Honor, Article 43(2) also provides for the right of any person to be accorded medical treatment. Your Honor, some of the suspects before you have been injured. Some of them, their eyes are red because of the injuries. They have bloodshot eyes, which indeed needs immediate emergency medical treatment. And as such, none has been accorded within the 24 hours, after the 24 hours, and they are better off at their homes, where they can now personally secure and guarantee their rights. Your Honor, 2 points before I conclude. The application before you, my colleagues will clearly demonstrate, is a frivolous application. Your Honor, the DPP is entrusted under Article 157(11) to act in a manner that promotes public interest. Further, Your Honor, Section 4 of the ODPP Act, the DPP should act in a manner that promotes public confidence. The manner in which the arrests have been conducted, the treatment of the suspect while in custody, their continuous detention without trial, does not in any way promote public interest or instill public confidence in the prosecution. Your Honor, we are saddened that the IO who has taken the dog did not even take time to ascertain the age of these suspects. Your Honor, Section 8 of the Children's Act enjoins each party to act in a manner that promotes the best interest of children. So even seeking 10 days to continue holding a child who has parents reveals and clearly shows the malice behind this application, the misuse of custodial applications, which will be extrapolated by my colleague. And Your Honor, we will be urging you in our submission that for the case of the children, let them be released unconditionally to their parents. But for the rest of the suspects, Your Honor, let them be released unconditionally or on personal bonds. Your Honor, I'll invite Ms. Wanjira to proceed.
Good afternoon, Your Honor. For the record, my name is Wanjira. Your Honor, a lot has been said to you this afternoon, but it is important to note that the prosecution has conveniently omitted the fact that there is no holding charge to continue holding the respondents. The application, you have been told, is premised on Article 49, 1 specifically F, G, and H, I believe. To quote Justice Kimaru in Michael Rotich versus the Republic, the citation, which is 2016 EKLR, Justice Kimaru came to the conclusion that the proper and constitutional meaning of being informed for detention continuing as you're being sought by the prosecution, the proper constitutional meaning of that phrase and of Article 49 is for there to be presented a holding charge. The only thing you have been brought, or the only thing you have been presented to, Your Honor, is just a narrative based solely on the word of the inspector that there are offenses correctly known and contemplated in law, but these do not amount to holding charges. In the alternative, Your Honor, you have been told that there are compelling reasons to continue holding them. So there is no holding charge, but there are compelling reasons. In regards to the compelling reason, Your Honor, it takes us to Section 36 again, on which this application is premised. When looking at compelling circumstances, Your Honor, you should be looking at the nature of the offense, the general nature of the evidence tabled before you, the inquiries that have been made by the police, and the reasons that necessitate the continued holding of the respondents. I think everybody here has heard the police inspector speak in a futuristic sense. I will record, I will present, I will annex, I will disclose, I will attach, I will audit. But he has brought you nothing. Your Honor, he has not presented you with names of complainants. He has not presented you with OB numbers. He has not presented you with photographs of allegedly damaged vehicles. He has brought you nothing. Your Honor, the only compelling material you have been tabled or you have been presented with is just the word of the inspector.